Here are 8 landmark judgments that you absolutely need to know about. The first case is Kesavananda Bharati versus the state of Kerala. Swami Kesavananda Bharati, head of the Hindu monastery in the Kasaragod district of Kerala, challenged the Kerala government's attempts under 2 land reform acts to impose restrictions on the management of his property. A noted Indian jurist convinced Swami into filing his petition under Article 26, concerning the right to manage religiously owned property without government interference. The top court, while delivering its judgment, considered the amendments done in a previous case and gave 11 separate judgments, agreeing on some points while dismissing some points. The Supreme Court held that although no part of the Constitution, including fundamental rights, was beyond the Parliament's amending power, the basic structure of the Constitution could not be abrogated even by a constitutional amendment. The second case is Vishaka and others versus the state of Rajasthan. A social worker in Rajasthan was gang raped for halting child marriage. Later, she complained about the accused, but the trial court acquitted the accused. She didn't lose hope, and seeing her determination, all female social workers gave their support. They all filed a writ petition in the Supreme Court of India under the name Vishaka against the state of Rajasthan and the Union of India to enforce the fundamental rights of working women as per Articles 14, 19 and 21 of the Constitution of India. The judgment was given by a bench of 3 judges. The bench provided the basic definitions of sexual harassment at the workplace and provided Vishaka with guidelines to deal with it, which formed the basis of the Sexual Harassment of Women at Workplace Act of 2013. It is one of the significant legal victories for women's groups in India. It is a landmark judgment throughout history in cases of inappropriate behavior which have been decided by the Supreme Court that deal with the evil of sexual harassment of women at the workplace. The third case is Shreya Singhal versus the Union of India. The police arrested 2 women for posting allegedly offensive and objectionable comments on Facebook about the propriety of shutting down the city of Mumbai after the death of a political leader. The police made the arrests under Section 66A of the Information Technology Act of 2000. It punishes any person who sends through a computer resource or communication device any information that is grossly offensive or with the knowledge of its falsity. On 24th March 2015, the Supreme Court struck down Section 66A as unconstitutional as it violated the right to freedom of expression guaranteed under Article 19(1)A of the Constitution. This was hailed as a major step in the country's quest for freedom of speech and expression. And the last case is Navtej Singh Johar versus the Union of India. In 2009, the Delhi High Court held Section 377 to be unconstitutional. Section 377 pertained to consensual sexual conduct between 2 adults of the same sex. In 2014, the Supreme Court granted Section 377 the stamp of approval. Navtej Singh Johar, who identified as part of the LGBTQ+ community, filed a writ petition in the Supreme Court in 2016. It was to seek recognition of the right to sexuality, sexual autonomy, and choice of a sexual partner to be part of the right to life guaranteed by Article 21 of the Constitution of India. In 2018, a 5-judge bench unanimously struck down Section 377. The Supreme Court made it clear that the choice of LGBT people to enter into intimate sexual relations with those of the same sex was an exercise of their personal choice. It is an expression of their autonomy and self-determination. They are equally entitled to the enforcement of their fundamental rights. Now, LGBT individuals are legally allowed to engage in consensual intercourse, making it one of the historic Supreme Court judgments.